My name is Kyle Kanan. I am the Policy Director at the Wisconsin Institute for Law and Liberty. Today we're going to talk about the administrative state in Wisconsin. So I got four speakers here, including myself. We have Colleen Lindgren from the Pacific Legal Foundation, my colleague Lucas Weber, who's a deputy counsel at Will. He often litigates on separation of powers issues, and then Patrick McLaughlin, who's a research fellow at the Hoover Institution at Stanford and also a visiting fellow at Pacific Legal Foundation. Do a quick rundown on our two organizations. So Wisconsin Institute for Law and Liberty, we are a nonprofit law and policy center, nonpartisan, based out of Milwaukee. You probably know us mostly for our litigation work. We do a lot of legal work. We sue the government a lot, but we also do a lot of policy work here in the state capitol, and grateful for all your partnership working on issues together. And Colleen, I don't know if you can do it. Well, you can do it when you come up. Yeah, okay. We'll just do a quick intro of why we're here today. So Wisconsin's a very heavily regulated state. We're 13th most regulated in the country with 165,000 regulatory restrictions, which I'll have Pat go through. Obviously, regulations cost businesses, cost your constituents money and time. And obviously, we've had a big court decision in recent months that kind of impact how our regulatory structure works in the state, and that's what we're going to plan to go over today. So the purpose today is understand how our rulemaking system works, why oversight's important, what tools you guys have left as legislators left in the toolbox to make regulation more accountable in the state. And I think I'll hand it over to Colleen.
All right. Well, thank you, Kyle, for that kind introduction. And like you said, I'm Colleen Lindgren. I work at the Pacific Legal Foundation. I'm the state policy manager there. So that means I get to work with folks like you all around the country on state policy matters. And I'm just going to quickly kind of set the stage for the conversation a little bit and talk from a national perspective. We work in all 50 states, both in court and at the state and federal level for legislative advocacy. And so day to day, we're working with legislators and staffers and other groups like Wisconsin Institute for Law and Liberty to do things like rein in the administrative state. And for 50 years, PLF has been representing clients free of charge when their constitutional rights are violated by the government. And we've done this across a variety of issue areas, predominantly in property rights and separation of powers. We also work on equality and opportunity under the law, so things like free speech, occupational licensing, and so forth. And we've become very passionate, particularly, and developed expertise in dealing with advocating for proper separation of powers and addressing regulatory reform issues, because we've seen the government become adverse to individuals and businesses every day. And I don't think that that's what most people think of when they think of running for office or when they think of how our government should be structured. But sadly, that tends to be the case, both at the state and federal level. And so I would assume that most of the constituent issues that arise in your offices every day, you could tie back to at least one regulation, at least one agency, and at least one place where the administrative state has intervened inappropriately. And when I talk about the administrative state, we're really talking about what some people call the fourth branch of government, which is agencies, and really uncontrolled agencies, or agencies that the executive and legislative have abdicated power to. And so when this happens, the people really have no say. They elect officials who, and if you give away your power, that really breaks down the electoral process and the meaning behind it. And so, when agencies really exist to take care of delegated tasks on behalf of constituents. So once this breaks down, and once we lose that mentality in government, we lose accountability, we lose transparency, and we make the agencies and then therefore the individuals working with them adverse to each other. And so when we're talking about regulatory reform, this is a really broad term. But I hope in this room we can agree on main principles. First, a lot of it's just plain deregulation. I have a friend in the governor's office in Virginia who has been tasked with managing the Office of Regulatory Management there. And one of the big things that they've done is just go through and see what is outdated, particularly in the area of technology. What laws don't need to be in the books, making sure that regulations are up to speed, that they're correct, that they're necessary. And in Virginia, in just the last few years, they have just deleted 14 times worth the original King James Bible in words. And so my friend there likes to say, if God could say what he needed to in this much space, why does government need more? And it just kind of puts things into perspective about those aren't laws, those are just rules and regulations. And so transparency and accountability are really core to the issue that's brought us here today. And things like cost-benefit analysis, sunset sunrise review, and other accountability measures are essential. And a lot of states have these in some forms. A lot of them need to be updated or tweaked for the 21st century. And some of my colleagues are going to talk about that a little bit later, so I won't go into that right now. But these things aren't costly, but they save costs to taxpayers, to businesses, and the state in general. And that's really what this whole system should be about, what the administrative system should be about. And at the end of the day, lawmaking is public, right? What legislators are called to do, and then what the governor is called to do, those are very public processes, and rulemaking should be that as well. And there should be accountability. And states like Idaho and Virginia and Texas and others have taken the lead on this in the last few years. And so I think the main tenet of reform for those who are concerned about this is really looking at going back to what the constitutional separation of powers really means and what it was intended for. And so I just want to talk quickly about how the Constitution separates these powers and why it's important. And a lot of the conversation that you'll probably hear on this is really at the federal level, but it applies to the states equally, because the states have modeled, in most cases, their form of government after the federal model. And that's a good thing. That's a good thing, right? The U.S. Constitution's framework carefully vests or grants different powers from the people to each of the three branches of government, and the Constitution grants additional powers back to each to check potential abuse or overreach of other branches' powers. And so the Constitution's structural provisions form the backbone of what we call separation of powers, which sounds very esoteric, but actually is a thing that affects every aspect of the law, every aspect of your constituents' daily lives and your daily life. And this proper separation protects against abuses that undermine freedom, and they have to be fully intact to really protect liberty. So without these protections, things like the Bill of Rights are really just not much more than a wish list. And Justice Scalia famously once addressed Congress and pointed out that every dictator in the world has a Bill of Rights. And it isn't the Bill of Rights that produces freedom, it's the structure of government that prevents anybody from seizing all the power. So even North Korea and China have constitutions that guarantee things to their residents. And the former Soviet Union's constitution ensured the right to housing, to work, to rest, to much more, but that was completely meaningless because there were no actual checks or balances or meaningful structure. And so here, we are blessed that in their wisdom, the founders set up a system of government with a healthy tension, right? So between the branches that should result in the electorate being represented and served, and states followed this model, and Wisconsin is one of them. And so over the last several decades, starting with the New Deal, I would argue that Americans have really been dealt a bad hand with that. It was a bad deal. And it was a bad deal for many reasons, but particularly because the administrative state grew into the behemoth that it is today at the federal level, and the states, unfortunately, followed suit. And so at both levels, each of the three branches of government have wrongfully relinquished authority to the state. So at the legislative level, this happens when delegation of lawmaking authority is given to regulatory agencies. At the executive level, this is by not holding independent agency officials accountable. They're not independent, they're in the executive. And then at the judicial branch, we see this come out where bias is shown towards agencies, often under the guise of expertise or them being the authority, the independent agency, when in reality, that skews the scales of justice in favor of the government over individuals or businesses. And courts shouldn't be in the business of skewing either way, right? And so one of the questions that I get asked all the time at legislatures is, what are the real world effects? So who's really being harmed and how? And so I want to tell 3 quick stories about our clients so you understand a little bit more about PLF and where we're coming from and hopefully how we can help you as you advocate for your constituents. So in the bottom left-hand corner here, we have Mike and Chantel Sackett. And I like to say that this is our picture of them walking on water because that's what the EPA said they were doing. This is their property in northern Idaho that they purchased, I want to say about 20 years ago at this point, and they planned to build a house on it. And not only was it a lot, but it was in a development already. There were already houses around them, and it is not on water. But the EPA would not give them a permit to build, even though other people had been building. The time they applied, they were told, no, you're too close to a body of water that we regulate. Therefore, we can tell you can't build on this property. And it took them 12 years in 2 cases, including going all the way to the Supreme Court, to win and to be vindicated and be able to use their property. So not only was that a violation of their right to use their property for the benefit of themselves and their family, but it was an agency going above and beyond in its interpretation of what Congress had allowed it to do. In the middle, we have Shana Rogers. And Shana is a resident of the state of California. She's also a property manager and a landlord. And in 2019, Shana had a very unfortunate experience with one of her renters. And he turned violent. There were issues in the building. He assaulted somebody, and she was very concerned. She wanted to get him out, get him the help that he needed, and make sure that her residents were safe. And she went through court proceedings to do that. After the local court had given her, had approved the eviction process, ordered this gentleman to move, about 2 weeks before the date that he was supposed to move, the California governor enacted a moratorium on evictions. So even though there was a court order saying that this gentleman needed to move and also demonstrating that he was unsafe, she was unable to get him out of her house for years. And so, again, a violation of her property rights, an overreach by the government, and an absolute abuse of executive power. And the third photo there is of a woman named Jamie Leach. And Jamie is a nurse. Her husband was a crop duster. They live in Oklahoma. And about 30 years ago, they started a business doing all sorts of manufacturing of items to help mothers and infants. And Jamie was inspired to start this by her own experience working with mothers and infants in hospitals and their needs. And they built a great family business up. They had dozens of employees. And about 6 or 7 years ago, Jamie and her husband and her children who help run the business ended up being personally attacked by the Consumer Safety Product Commission. And they've never really gotten down to why, but they went after them. And they took on more power than they were granted. And unfortunately, under the administration at the time, they were allowed to do this. And they have spent almost 8 years in court. They've actually gone out of business, but they're continuing to fight because they want to make sure that this doesn't happen to other individuals, that agencies are held accountable by executives at the federal and the state level, and then also by the legislatures as well. And so they're actually advocates now, working to help individuals around the country so it doesn't happen to them. And working on issues like addressing agency adjudication and other problems that arose in their case. And these people are just a few of many that we know that are affected every day around the country. Millions of Americans' rights are violated. But the good news here is that states are really at the forefront of being able to address this problem head on. And the really good news in Wisconsin is that Wisconsin's ahead of the curve. Wisconsin adopted a state version of the Federal Reins Act in 2017. It was the second state to do so. And since then, I think about 6 or 7 other states have followed suit, and others have done similar types of reforms. And Wisconsin's also one of only a handful of states to end judicial deference in law, and they did that in 2018. And so you're already a step ahead of a lot of states. A lot of states in the last few years have, since 2022 specifically, have really seen demonstrated what happens when you get lax about how your branches are interacting and the accountability that's there. And so In the last few years, we've tracked around 200 separation of powers related reforms across the states, from broad efforts like legislative oversight and reins to deference reform to specific process-oriented reforms relating to sunset or other regulatory review. But one thing is the same everywhere, and that's that people are recognizing that the administrative state is out of control, and elected officials have a duty to stop it, and they have the power, the constitutional power to do so, and the impetus to do so. And it is entirely appropriate to switch the narrative back to what agencies were initially expected to be, which is tools in the tool belt of public servants. And so my encouragement to you, and I hope you'll get more information on specifics moving forward on how to do this for Wisconsin, but my hope for you is that you will really feel empowered to help your constituents, the individuals and businesses, by making sure that the legislature is doing its role, and to the extent it can, that the governor's office is doing its role to make sure that agencies are tools, that when their services are no longer needed or they need to change, that they do, that their rules, that the authority that's been delegated is specific to making sure that rules are rulemaking is necessary, and that there's going to be accountability measures for rules that have the effect of law. And so this is actually, I think it's a positive thing in many, it's a positive thing. There may be bad things happening, but there's a lot that can be done. And so I hope that Pacific Legal Foundation can really come alongside folks in Wisconsin and help with this, with both our litigation and legislative expertise, and help apply these constitutional principles to any reform. The constitutional principles of accountability and transparency and just proper separation of powers that will protect everyone in the process. It protects the branches and it protects the constituents. And so with that, I'm going to pass it over to Patrick, who's going to go into a little bit more detail about what's happening in Wisconsin specifically and how we can put these principles into practice. Thank you.
Hey everyone, I'm Patrick McLaughlin. When Kyle invited me to come out here, he said, come do your, I think the exact request was, come do your economics thing. So I'm going to do my economics thing. By way of background, I do have a PhD in economics. I've been working in this space of regulation for well over a decade. And I got into this space because I frankly saw a data opportunity. By that, I mean there was a data gap that I could zoom in and fill. And if you're an economist, you need to publish in economics journals. By filling a data gap, you can get into these journals and excel in the field. So I'm going to give you a little bit of a story about how I produced this figure here and the numbers you're seeing. And also, you should grab the report on your way out. If you haven't, you'll get a lot more details about what I'm about to present in this report. But when I first got into studying regulation, economists need data to study things like if you're looking at how tax rate changes would affect income or would affect the overall revenue that the government collects, you need data, right? You need to have that tax rate. You need to know how much taxes are collected in previous years in order to evaluate what a change in tax rates would do to future years. With regulation, we didn't have such data. We didn't have numbers to evaluate questions like, what does it mean if Wisconsin's regulatory code grows unstopped for decades and decades? What does that mean in terms of economic outcomes? What does it mean for you and your constituents? So to be able to answer those questions, I set out to create the data with which we could do some research. And so this started with the realization that I was not going to be able to create data about regulation by reading stuff myself. There's simply too much text to get through in a lifetime. And so I started using computer programs early on to go through the text of regulations and identify things that matter most. And the things that matter most in regulations are the words shall and must and may not. Words that create obligations on the part of businesses or individuals to do something, or prohibitions from doing something. You may not do this or that. And so that's one simple way of looking at how much regulation is there on the books in Wisconsin or any state at different points in time. And then once we have data on that, we can evaluate what does it do to overall economic growth, for example, if regulation keeps on growing, or in those few states that have cut regulation, can we look at how that affects growth or employment or the creation of new firms? And so that's where this figure here came from. This project ended up being called the Reg Data Project. You can find it online, regdata.org. You can also find this report on the Wisconsin, on the WIL website. I'm going to show you some more features of the website that they've built in there. But the bottom line here, I think the takeaway for Wisconsinites is Wisconsin's pretty regulated nationally, but also regionally. Wisconsin is the second most regulated state in the Midwest. I will highlight that it's about 60, you can't read this, but Minnesota has about 98,900 regulatory restrictions, the shalls and the musts on the books. Wisconsin has 165,000 on the books. It's about 66% more in Wisconsin than in Minnesota. 5 times more, 5.25 times more than in Idaho. I live over in Washington State. I can drive across the border from Washington to Idaho into a state that's much less regulated. And lo and behold, the sky doesn't fall. Safety outcomes are the same. Environmental outcomes are the same. And I think the same thing applies here in Wisconsin, Minnesota. You can drive over to Minnesota where it's 66% less regulated than Wisconsin, and you aren't going to find suddenly that worker safety has gone down tremendously or that the environment isn't being protected. So one central question that you should ask yourself after being presented data like this is, what are we getting in Wisconsin for being that much more regulated than Minnesota, than Iowa, than Indiana? I can't tell you what you're getting, but I can tell you what you're losing. There's all sorts of economic consequences now that we have data that we can highlight about being heavily regulated like Wisconsin is. And I think the central theme you want to keep in mind here is every dollar spent on regulatory compliance or every second of time spent on regulatory compliance is necessarily not a dollar or a second of time spent on making new stuff, investing in productivity, coming up with new ways to do business. So in economics, this is called the opportunity cost. Opportunity cost of regulatory compliance is you're not spending your time doing something else, building productive businesses, for example. And when you're able to study this with data, as I've been able to, you can get to some very, very large effects of this opportunity cost of regulation. And one of the first studies I produced, once I was able to map out how regulated the U.S. economy is overall over time, I was able to study what would happen if regulation didn't grow in the way that it did grow. So this is at the national level for federal regulations. I published a study a few years ago that looked at a simulation. What would have happened in the U.S. if regulations, instead of consistently accumulating over time, had been held constant at the level we saw in 1980? So just imagine if we have about 500,000 regulatory restrictions on the books at the federal level in 1980. Right now we're at about 1.1 million on the books. But instead of it growing to 1.1 million, what if it was held constant at about 500,000 over time? What would the economy look like? We ran that simulation and we found that the economy would have been about 25% larger if it had been less regulated, if regulations hadn't grown over time. That's a growth rate effect of 0.8 of 1 percentage point. So if you think about economic growth overall, typically we're talking about 3% growth from year to year for the national economy. Wisconsin's often a little bit higher. So if you add 0.8 of 1 percentage point, you're going from 3 to 3.8%. That's huge. That's a massive effect. That's how the economy could have been 25% larger. I studied this in other areas too, other contexts. I'll highlight a few of the other studies of growth in a little bit. But we also were able to look at things like, are there new businesses formed at different rates when regulation is less or when it's more? And so one study put out a result that showed that a 10% increase in regulation leads to a 0.5% loss in new business formation rate. So 0.5 percentage point loss of new business formation. You get fewer new businesses when you're more regulated. It's also a negative outcome that you probably want to try to avoid. The state of Virginia is worth highlighting too. Colleen mentioned them earlier. They've been able to evaluate the effects of deregulation as they've been going through this deregulatory effort under the Office of Regulatory Management under Governor Youngkin there. They've done it in a very different way than the methods I've just been highlighting here. Instead of using data like I've been talking about here and putting those data into models, running simulations, what would happen in this scenario or that scenario. For Virginia, they did cost-benefit analysis on every single deregulatory action that they took. And they've been able to add up what are the cost savings of deregulation in Virginia so far. And they've got to a number that's pretty big. So far, they're at $1.2 billion in cost savings annually for the entire state of Virginia. So it's a different way of getting to the same sort of result. The result being, I want to hammer this home, the cost of regulatory accumulation, the cost of having a bunch of regulations on the books is massive, but that also means the opportunity is massive. If you can manage to get rid of some percentage of that, 10, 20, 30% of that, you can increase your growth rate by substantial amounts. I'll quickly highlight a couple other studies. I think it's worth dwelling on. The fact that we have data has let people study things like poverty rates now. Like how can regulation be tied into poverty rates? What would your guess be on that? Maybe you think more regulation is somehow helping people that are impoverished. Turns out to be quite the opposite. We see in states that have more regulation, we have higher poverty rates. Likewise, income inequality. Where there's more regulation, you tend to see higher income inequality. So these sorts of data and these sorts of studies have been turning up some surprising results in some areas beyond just economic growth. So there is plenty of, let's call it, ammunition for people who do want to push forward on a regulatory reform agenda in Wisconsin. It's not just about growth. It's also about all sorts of other outcomes that people care about. So this is also on Will's website. Just break this down for you really quickly. What this is listing is the different departments and agencies in Wisconsin and how many regulations, how many regulatory restrictions they had on the books in different years. And so you can just see which agencies are adding more from year to year, or maybe some agencies are cutting from year to year. I'm going to come back to this in a little bit, but I want to jump forward and make further the economic case for reform, for economic reform. And again, regulatory accumulation slows economic growth substantially. The estimate I gave you from that federal study, 0.8%, 8/10 of 1 percentage point, is probably low. We've studied this at the state level, as well as in a province in Canada, where there's been substantial deregulation that happened. And the effect is, well, the province in Canada was British Columbia, believe it or not. British Columbia back in 2001 set out to cut regulation by a third. They ended up cutting regulation by about 40% within 3 years. And as a result of deregulating that much, their growth rate increased by 1 to 1.4 percentage points, depending on how you set up your model. So that's a bigger effect even than what we saw at the federal level. And we've seen one study put the effect up to 2 percentage points gained. So the range there is 0.8 to 2%, right? 2 percentage points that could be gained. I wanted to play around with that and say what could happen in Wisconsin, what could be gained here if you assume different effects of deregulating, running from 0.8 all the way up to 2%. And so that's what this table, this is also in that report that you should grab a copy of before you leave. But if we assume a 3.5% growth rate in Wisconsin from year to year, the question we're asking in this table is, what would a 10% reduction look like? A 20% reduction, 30 and 40 reduction in the amount of regulations on the books under these different scenarios, 1 percentage point or 0.8 or 1.4, different sort of assumptions about the responsiveness of the economy to deregulation. So I'll let you look at this. I'm not going to highlight everything in detail here in this little talk. I'll just point to one of these little squares here, assuming the sort of central estimate, a 1 percentage point response to a 36% red tape reduction, which is a realistic reduction. I can talk about other states that have cut red tape. 36% is very achievable. If you cut 36% and the economy increases the growth rate by 1 percentage point, then your growth rate is going to be over 4% annually as a result. That translates to, I have the number written down here, about $13.25 billion extra dollars in the economy of Wisconsin by the year 2037. So that is making very realistic assumptions and very achievable reductions. That's the gain that you could be having here. So how would this be accomplished? Just to highlight some of what does reg reform look like. Colleen gave some of her ideas on this. Some of these are going to be repeated probably throughout. I think, the first thing whenever I'm talking to an audience about reg reform, I do point out the importance of a REINS Act. Good for you, you already have that. The second thing I point out is you have to have some sort of mechanism in place to cut back all this red tape that is built up. And red tape builds up everywhere. This is not unique to Wisconsin. Every state has had the tendency for regulations to pile up. And unless you actively manage it and do something to cut back on it, you're going to be in the same boat as Wisconsin. So there are different ways to achieve this. Some states have emulated what happened in British Columbia, where a governor, or in some states a legislature, simply told the agencies, you must cut X% of regulations. Usually you see 25 or 30, sometimes 33% as the target. And then subsequently, once they cut that number, what we saw in British Columbia was they adopted a 1 in, X out. So in some years it would be 1 in, 1 out. Some years it would be 1 in, 2 out. But a way of maintaining that reduction. Otherwise, if you just go back to business as normal, you're going to see regulations start to pile up again. So the typical process we've seen be successful, this is also what's going on in Virginia, is they have some targeted amount that they cut by, and then after that cut, that 25% reduction, say to start off with, you then try to meter how much is added. And for everything that's added afterwards, get rid of something else. That will keep you at a nice, healthy, new level of regulation. Now, that metering is important. Like for this to succeed in any state, you just have to be able to measure things. We've seen plenty of states, as well as plenty of presidents in D.C. and Washington, say we're going to get rid of the old stuff, we're going to cut red tape, but if you don't have a baseline, if you don't have somewhere to start, it's not nearly as effective as in those places where you do have a baseline. So that's one of the, I think, main keys for a state that's looking to do regulatory reform. Have some way of measuring where you are to start with. That could be cost analysis. That's what President Trump is trying to do at the federal level with deregulatory efforts there. Or it could be some sort of text-based metric, which what I've been presenting here, where you're looking at the actual text of regulations and seeing how much there is on the books right now and then tracking how that changes over time. So having data is key to accomplishing this. And it's also key, a third element of regulatory reform is having data on costs and benefits of new and old regulations. This might be asking too much of a lot of places if they aren't willing to put the line items in the budget for paying for cost-benefit analysis. But if you're thinking about things like a REINS Act, how do people vote on a REINS Act without data about the costs or benefits of that regulation? I think that might be, in my mind, that would be ideal, that we have good data produced at a regular rate about all new regulations being proposed, as well as the existing regs on the books. And then fourth and finally, oversight has been a key component for success. And I'm going to go back to this slide here earlier. I made this way of tracking regulation over time and by agency by request, actually. I was talking to the governor of Oklahoma years ago, and the governor of Oklahoma had, by executive order, implemented one of these targeted reduction plans in the states. And he told all the agencies to cut at least 25% in his term. And the problem he ran into was the agencies weren't communicating back to him what they're doing. Some of them were simply ignoring him, and he didn't have a whole lot of power to stop them. And so I ended up building something similar here for Oklahoma. The idea was this lets the governor in Oklahoma look in on which agencies are doing what, which agencies are actually being successful in cutting red tape and which ones are not. And then he can call in those appointees that he needs to and have a good meeting if he needs to have that sort of meeting. You know what I mean? I tell this story because, if you're considering some sort of regulatory reform options here in Wisconsin, I would point to Virginia as a better model to follow than Oklahoma. Virginia set up an Office of Regulatory Management working in the governor's office. This, of course, could be set up in the legislature as well. But someone whose job it is to look in on the agencies, communicate with the agencies on a regular basis, track progress towards your goal, and occasionally crack the whip if that's what you have to do to make them work towards that goal, has been a very effective model. On the other hand, the states that we've seen try to go through regulatory reform without setting up an office or having someone's job explicitly be regulatory reform, if it's added to the portfolio of other jobs that you have, it tends to be much less successful. So creating some sort of mechanism for oversight has been what I've observed to be very key for success in this space. And I think here we're going to hand it over to Lucas.
Thanks, Patrick. All right, hey everybody, I'm Lucas Weber, attorney with Will. We are actually going to pass over that slide. I'm going to talk a little bit more with that background on the Wisconsin-specific process, kind of what our statute actually writes, what the rulemaking process is, which is probably familiar to this crowd, but maybe not, and then how the most recent Evers v. Markline decision changed that, and where do we go from here. So Wisconsin, just by way of background, like every state, we have a Republican form of government. It's required by the Constitution. At statehood and for the decades after, the Supreme Court of Wisconsin zealously guarded the legislative power. They would never allow the legislature to delegate that away for rulemaking. It just didn't exist. Any rule that was passed or any law that was passed that left it up to the agency to fill in the gaps was struck down almost immediately. The laws had to be complete when they were there. That all began to change around 1900 as government began to grow, agencies began to grow. Thinking of this change with the progressive movement in Wisconsin, and delegations became allowed. Those delegations, the way that was justified by the court was you could delegate your authority as long as the legislature maintained control over that rulemaking process. Very similar to what we see at the federal level. You give your power away, but it's your power, legislature, so you have to have the final say. You got to be able to have control over it. If you don't like what they're doing with your power, you should be able to stop it. So that's kind of where we had been for decades. In Wisconsin, we developed the Chapter 227 rulemaking process. For those on the side of them, you probably can't see this slide, but that's all right. I'll just very high level it, not talking about everything, but the big things. Rulemaking begins with a scope statement. An agency will have a scope statement that they'll prepare saying we want to write a rule on X, Y, Z. That scope statement gets approved by the agency. It gets sent to the Department of Administration. The Department of Administration reviews the scope statement, makes a determination if that scope statement has, the agency has the ability to actually do what they want to do, and makes that recommendation on whether they should be approved or not, sends the scope statement and their recommendation to the governor. The governor then gets to approve or deny the scope statement. If the governor approves the scope statement, the agency can start drafting the rule. So agency starts drafting the rule. Once they have a draft of the rule, they prepare what's called an economic impact analysis document, talking about the costs of the rule. So the cost, whatever the actual regulatory burden is that the rule is going to impose, also takes into account some of the benefits of the rule that could be out there. It's supposed to present kind of a complete picture of what the impact of this regulation would be. Those two documents, the draft rule and the EIA, then are subject to a public hearing. The agency can hold a hearing. They can accept public comment on the rule. If that economic impact analysis is over $10 million over 2 years, the REINS Act kicks in and rulemaking has to stop until the legislature passes a bill, which is signed into law by the governor, allowing it to continue. Legislative Council reviews draft rules for form, make sure that the agency is writing it in a way that makes sense. An agency will then finalize the rule, and this is kind of where the process now is a little up in the air. But once the agency has a final draft of the rule, it goes back to the governor for final approval. Once the governor approves that final draft rule, what the law says is it then goes to the legislature for passive review. So it's 30 days in a standing committee, then 30 days in a joint committee for review of administrative rules. And then if there's no objection at that time, the agency could publish the rule. That's historically how it's been. The legislature could, under the statutes, historically again, temporarily or indefinitely object, request modifications, hold hearings, things that would extend their oversight process. The Markline versus Evers, I have that wrong, it's Evers versus Markline. Sorry about that typo. But this was a lawsuit that came out over this past summer. Governor Evers filed the suit against the legislature, challenging some key oversight tools during the rulemaking process. So specifically, there were 5 statutes that were challenged there. The first was that a rule cannot be published until the Joint Committee for Review of Administrative Rules, or JCRAR, is done with their 30-day review. That statute basically said once, as part of this process, agency, once you get the final rule, you can't do anything with it until the legislature is done with its work. So we challenged that. The second was the ability of the legislature to temporarily object to a rule, which was, as the rule is in the process, you could just object to it for the rest of the legislative session. You could also have an indefinite objection to a proposed rule. They invoked that. Rulemaking on that subject couldn't go forward until the legislature affirmatively approved it. temporary suspension of an already promulgated rule. So if a rule was already on the books, but it turns out that the rule didn't do what the legislature intended for the agency to do, the legislature through JCRER and standing committees could go back and suspend that rule temporarily. And then the last one was allowing multiple suspensions of already promulgated rules. In Markline, the Supreme Court of Wisconsin determined that all 5 of those statutes violated the separation of powers and struck them all down. So it really significantly limited the legislature's ability to slow down or stop administrative rulemaking. As a result, the only way to actually stop a rule in the process or to roll back a rule that's gone through the process is for the legislature now to pass a bill and have the governor sign that bill into law. As a practical matter, of course, the governor's already approved every rule by the time it gets done and published, so you'd be asking the governor to effectively repeal a rule that he just approved. Seems unlikely, although, of course, a future governor could always come back and repeal those. I think, as a practical matter, we're going to see a large uptick in rules, especially these controversial rules. We've already seen some of this with like the building code that just came out, the DAT cap fees rule that's under consideration now. These are pretty controversial rules that the legislature had slowed down or exercised oversight on previously that are now moving forward because the legislature can't stop them. So what's next? What can the legislature do in a post-Markline era? I think first of all, the Markline only applied to JCRER's powers. The decision itself did not explicitly take away the standing committee's powers. So there's some question there as to whether the governor now can publish a rule immediately upon approving a final draft rule, or if the agency still has to submit that rule to the legislature for passive review. The statute that said that the agency can't publish the rule until JCRER had reviewed it is obviously not enforceable anymore. So I think it's sort of the argument is it's still implicit in that process. The governor is currently challenging the standing committee delay process as well. He wants a declaratory judgment that says he can publish rules or his agencies could publish rules immediately upon having the final draft approved. So that case is now pending. It was filed last month in Dane County. I don't think anything's happened with it yet. I think the legislature hasn't even filed an answer yet, but expect some change there. I don't know what will happen with that, but it's an open question. But what can the legislature do? So the standing committees still exist. The standing committee process is still there. So agencies, whether they think they should publish or not, are still required under law to submit those rules to the standing committee. The standing committee has some powers. They can still hold hearings on those rules. They could still request germane modifications to the rules. Again, there's some question whether the agency has to listen or do anything with that. I think that's the open question that litigation will understand. But the legislature still has powers here that they can do. They could still technically object to a rule. They could pass a law to repeal a rule or stop a rule. The governor would have to sign that law by bicameralism and presentment. But JCRER can no longer temporarily suspend a rule, which has already been promulgated. One other tool the legislature has is they can request an independent economic impact analysis. So we see this quite a bit with rules. For example, the building code rule came back. It had a $0 economic impact analysis. One of the reasons the legislature suspended that rule is they said that economic impact analysis was deficient. It's clearly wrong. This building code will obviously impose costs. Industry has said that. So we're going to suspend the rule. What the legislature could have done is they could, request that independent EIA. The independent EIA would be somebody other than the agency that they would contract with to look at the cost of that rule. If that independent EIA came back and was also over $10 million or more, it could still trigger the REINS Act. And the agencies have to pay for that if the difference between the two is greater than, I think it's 10% under state law. The only way, again, for the legislature to actually stop a rule, though, now is for the legislature to pass a bill and have the governor sign it into law. Certainly, future governors could be willing to do that. But I think we're going to see a lot more rulemaking happening, and it's, again, probably going to be the more controversial rules that come out. And so there's going to be a greater emphasis on the courts as we see going forward. I think one of the fundamental problems with the Evers v. Markline decision that wasn't really answered by the court in that case and just leaves a lot of head scratching is the legislature for decades has granted statutory authority to agencies to promulgate rules based on the understanding that they had the oversight on the back end. So they kind of gave their power based on this understanding. And now that understanding at the end is gone, but the grants of rulemaking power are still there. So it's sort of, are those grants of rulemaking power even valid anymore? I think there's probably another shoe to drop at some point in the future on that. So stay tuned. I think, what else we got? What can the lawmakers do? Some additional oversight stuff. So obviously targeted oversight hearings on proposed rules by standing committees. Standing committees can shed a lot of light on what's going on at the agencies, and focus on statutory authority, legislative intent, the costs of the rules, unintended effects of the rules, how it might impact the regulated community. We are preparing a rulemaking guide now, which is going to have some sample questions and things to ask on that I think could be helpful for anybody who's interested. That'll be available for the public, to everyone. Enforcing economic impact analysis requirements, I think, is really important, more important now than ever. Requesting those independent EIAs for what should be high-cost rules is vital. Holding committee hearings on those to get some more insight on it is also important. One other power the legislature has that's little used is the retrospective economic impact analysis power. You can take an existing rule that's been in force for years and get an economic impact analysis on how that rule has impacted the community it regulates. So you can actually find out, what is the impact of this rule? Has it been good? Has it been bad? Is there a better way to do it? Can we accomplish the same goal with an easier regulatory burden? That's the hope there. The legislature can obviously still, again, exercise suspension authority through presentment. You could pass a bill, send it to the governor. Certainly the governor probably wouldn't want to veto the rules he approved, but it helps build that record for future statutory clarification or a future repeal. And then just general agency oversight. The legislature has tremendous powers over agencies. You can subpoena agency officials. You can get records. You can hold hearings. The legislature should be exercising their power as much as possible to just make sure that everybody's doing the job that they are empowered by state law to do. And I'll turn it over to Ken.
All right, Lucas previewed that we're going to be coming out with a guide probably in the next month or so of what questions you should be asking if you have an oversight hearing. I just have a couple examples here. The first one is, were alternative approaches to regulation considered? So if you look at this upside down pyramid here, this is applied to kind of the occupational licensing regulation, but the idea is that full force regulation isn't often the most efficient way to achieve a regulatory goal. If you're trying to fix a problem, maybe there are other ways to fix that problem without fully going forward with a full-scale regulation. So that could be like independent certification. In the context of licenses, it's often like registration, state certification, or inspections on a property or something like that. Another one is, did the legislature ever consider the policy and reject it? I think that really goes to the intent of the legislature did not intend a regulation such as this to go forward, and that the agencies going forward with something that's contrary to something that the legislature already rejected really flies in the face of the separation of powers. And the last one here is, how do the agency calculate compliance costs? And I think this is where you kind of get in the weeds. I think this is where you can have a little bit of gamesmanship from the agency, and we've seen that through the reins process currently, that oftentimes the estimates that come back from agencies are probably underestimating the real cost to the regulated community. And I think by probing on, trying to get into the methodology, what data sources they used, all of that, it can kind of get to the bottom of whether or not the estimates that the agencies put forward were accurate or not. I think this one's just really quick.
All right. You got me for one more slide, I promise. Last one. This is just what can lawmakers do from a bill drafting perspective in kind of this diminished oversight era. The first is write self-executing laws that minimize the need for rulemaking, include more details in the laws, don't leave it up to agency officials to fill in those gaps. The second is you could prohibit rulemaking entirely. The department may not promulgate any administrative rules to interpret or administer this section, is one way you could do it. Maybe that doesn't have practical implications, or that will have practical implications, which is why it's important to have those self-executing laws. The rulemaking, rather than just grant a general grant, most laws we've seen over the years just say agencies shall promulgate rules to administer this section. It's a very broad grant of power. You can make that very explicit and say what they should grant the rules on and what those rules should explicitly say. And then you can always have You can always have expiration dates for those rules. You can say any rules adopted in this section shall expire after 2 years, 3 years, 4 years, whatever the legislature wants. You could say that for those ongoing rules. And then you can always ask legislative council to review existing grants of rulemaking authority when they're drafting new bills. So if you have a bill out there, what might the current statutes say and authorize them to do if you're going to create this new program? Just some things to consider as bill drafts are going forward.
Thank you, Lucas. It's kind of the last miscellaneous things. Obviously, I'll be talking about a little bit about the bills that are probably coming forward for a hearing, or that are coming forward for hearing tomorrow. But supporting constitutional or statutory oversight reforms to help reestablish some of those powers, that's another thing that lawmakers can do. There have been numerous efforts in the legislature here over the years. The Right to Rules Initiative, red tape review, proactively reviewing previously administered rules is another important way that you can tackle this issue. And then I think the biggest thing, and really when we talk about oversight hearings and passing bills, one of the things is raising awareness about these rules and their impact on your constituents is really important. So using your newsletter, social media to really talk about the impact of these is super important. One consideration, obviously the Evers v. Markline decision looked at a constitutional question. The legislature does have the power to change the Constitution, obviously. You got to go through 2 consecutive legislative sessions before it's presented to voters. That is an option here for, as you're looking at this oversight issue, reestablishing some of those powers that have been long held by the courts in the state before this decision. And then we talked about some of the statutory reforms that we'll go through real quick here. So a couple months ago, a package called the Red Tape Reset was introduced. There's a little one-pager over on one of the tables over there that kind of walks through it if you'd like to look at it. But why it matters, I think I won't rehash everything that Patrick and everyone kind of talked about already, but predictable rules, stronger economy, you have greater accountability and oversight, greater fairness, and it makes Wisconsin more competitive if we can roll back some of the excessive regulations on the books. So there's several bills, 4 bills in this package that I just wanted to quickly review. The first one is a sunset review bill. This is introduced by Representative Nealon and Senator Nass. The purpose of the bill is to ensure that every administrative rule that's on the books is periodically reviewed and evaluated and justified for whether or not it is still necessary to achieve a regulatory goal. So what the bill does, it creates a 7-year sunset review. So that would put all the rules on a 7-year cyclical review process that JCRER approves. And the rules are not authorized, that are not reauthorized automatically expire under the bill. So it cleans up the code, builds greater accountability, kind of brings some of these rules that have been on the books for years and decades back to the forefront and gives your constituents the opportunity to weigh in on them again. And as I said, gives citizens a voice. Regulatory budgeting, this is kind of the concept that Patrick had talked about, and there's several ways that this is, has been done. I think at the federal level, they've done the 1 in, 2 out concept. The concept that is in the bill here says that any new regulations that impose costs on the regulated community have to be offset. Otherwise, the legislature has to take a vote on that new regulation. So what that does is brings accountability back to the legislative branch where it belongs and ensures that we're not accumulating a bunch of costly regulations on top of your constituents. I won't go through all this again. These are, I think we talked about a number of these examples with Virginia. I'll note one thing with Virginia's example. So they've used a lot of AI to go through and really look at the rules and really dive in and really speed up this process to deregulate where necessary. Patrick talked about the $1.2 billion a year it's saved, but I think just one practical impact, I think just a change in the building code that they did cut the average cost to build a new home by 5.6% or $24,000. So that's like a real impact that your constituents can feel when you're looking at some of these regulations that raise costs on them. And I think you can kind of see here these reform states that have been doing several of these reform efforts, you can see the regulatory restrictions have been going down while states like Wisconsin have continued to go up. Another bill by Representative Tussler and Senator Wimberger would introduce fee shifting for statutory and constitutional challenges to unlawful regulations. So let's say a constituent of yours believes that a regulation that they're subject to was either illegally promulgated through a procedural problem or that it is not constitutional. They have to typically go out and hire an attorney, pay the fees. It's a big risk for them to to move that case forward. This bill would simply say that if the government loses in those cases, that the fees, the attorney's fees of the person suing, would be covered by the government. I think this is an important accountability tool to ensure that the government doesn't overreach and pass regulations that they know are likely to be challenged as unlawful. And then the last bill by Senator Hutton and Representative Knodel kind of closes a little loophole in our scope statement process right now. Oftentimes, agencies will promulgate the same two rules with a similar scope statement or the same scope statement. So often do the emergency rule and the permanent rule under the same scope statement, or take a scope statement and promulgate multiple rules out of it. That takes a key piece of the accountability out of the process here. That scope statement is meant to notify the public when a rule is pending, and by trying to kind of piggyback multiple rules on one scope statement, it takes away an important step for them to be notified. So that is the bill package.